we have legal issues as well as technical ones. So our next guest is going to talk about that. So Christopher Johnson is a space law advisor at the Secure World Foundation and professor of law, an adjunct professor of law at the Georgetown University Law Center, where he co-teaches the space law seminar. He's also a faculty member at ISU and a member of the International Institute of Space Law. He's written widely on space law and policy issues and represents the Secure World Foundation at the legal subcommittee of the United Nations Committee on the Peaceful Use of Outer Space. Prior to joining SWF, Mr. Johnson works as an attorney in New York City and entered the space field in 2010 as an intern at the United Nations Office for Outer Space Affairs in Vienna during 53rd Committee on the Peaceful Uses of Outer Space. He's also served as an intern in the Office of International Interagency Relations at NASA headquarters and as a legal stagiaire in the International Law and EU Legal Affairs Division at ESA's legal department at ESA headquarters in Paris. So he's going to tell us all the reasons we can't do this stuff. Not just kidding.
Well, thank you for the introduction. Legal aspects of asteroid mining. You know, as an overview of my presentation, this is what I'm going to be talking about. First, I'm going to talk about the Outer Space Treaty for a few minutes, including and really focus on the rights, the obligations, and the prohibitions that exist in the Outer Space Treaty. You need to know all this stuff because it, you know, drives down at the national level. I'm going to spend just a few minutes on the Moon Agreement, just for the sake of comprehensiveness in my remarks, and then I'll really talk about how the story is happening at the national level through national approaches, through national space legislation. There is, work afoot at the United Nations level, the UN Working Group on Space Resources, and then hopefully some new insights that I can offer or some wisdom in this regulatory roadmap for asteroid miners, what you should be thinking about. So first, let's start with basics of the Outer Space Treaty, freedom of exploration and use in Article 1. And I'm only going to talk about those, I've highlighted it. This is Article 1, Sentence 1. The exploration and use of outer space, including the moon and other celestial bodies, shall be carried out for the benefit and in the interest of all countries, irrespective of their degree of economic or scientific development, and shall be the province of all mankind. So what is the subject of this sentence? Not space itself, but the exploration and use. The exploration and use shall be the province of all mankind. Keep that in mind as we move forward. Article 1 creates these great rights that we exercise and that states exercise. Sentence 2, outer space, including the moon and other celestial bodies, shall be free for exploration and use. Exploration and use. I hear some, perhaps folks need to mute their microphones. So shall be free for exploration and use. This is another great right. And in fact, the words use exist even in the title of the treaty. Further on a basis of equality and in accordance with international law, and there shall be free access to all areas of celestial bodies. Next, sentence 3, there shall be freedom of scientific investigations in space. So we have these great rights in Article 1, which the treaty creates. However, we have to mention Article 6 dealing with international responsibility. State parties to the treaty bear international responsibility for all their national activities, whether those are conducted by non-governmental entities or governmental entities. So, it is, I know that there's that great libertarian saying, the question is not who is going to, I should not be asking who's going to let me, I should ask who's going to stop me. This is the opposite. Please don't ask this in space law, because states are responsible. States have this obligation of responsibility for your national activities. They have this obligation for assuring that national activities are carried out in conformity with the provisions set forth in the present treaty. And in fact, in relation to non-governmental entities, a positive obligation of authorization and continuing supervision. States are required to authorize and supervise non-governmental entities and look at what they want to do in space. Now, getting to Article 2, and I said the treaty is a balancing of these elements. Article 2 is this principle of non-appropriation. Let's take a look at it. Outer space is not subject to national appropriation, whether it is by claim of sovereignty, or by means of use, or by means of occupation, or by any other means. Now, this sentence is strangely phrased in that it does not clearly create a prohibition. You know, you could say, if you wanted to be clear, you could say states are prohibited from national appropriation, but it gives this definition that outer space is not subject to appropriation. And so whether if a state was to make a claim of sovereignty or use space or space resources or occupy space or do other things, none of those acts legitimize or concretize or validate a national appropriation, which is kind of a territorial appropriation or claiming sovereignty over a particular domain in the space domain. Now, we balance Article 2 with Article 1. Article 1, as we mentioned, freedom of exploration and use. Use is in the very title. However, balanced against that is Article 2. Outer space is simply not subject to national appropriation. Put those together, there's been decades of debate on what that actually means. Those decades of debate attest to the underlying argument or the conclusion that, in fact, perhaps it is not perfectly clear in the treaty. If there's all these folks who can debate about the limits and boundaries of how we can use space, although we look at how nations have interpreted their rights under Article 1, and especially through national space legislation, and we get to a point where, in fact, it is believed, and the general consensus is that we can use space resources. We cannot make claims of national appropriation, which would legitimize national appropriation, but we can certainly use space resources, balanced against those obligations of responsibility, authorization, and supervision, and that states assure that national activities conform with international law. What about the Moon Agreement? Well, quickly, they wrapped up negotiation in 1979, but it did not enter into force until 1984. As of 2021, there's these 18 states parties of the Moon Agreement and 4 other signatories who are therefore bound to not, defeat the purposes of the treaty, even if they're not particularly bound by it. So my advice is, if you want to find, own, use, or sell space resources, maybe don't have offices in those countries until you can get more legal clarity and certainty and predictability from those governments. I also mentioned that, just note that Australia is one of those countries which is party to the Moon Agreement. Why do I say this all about the Moon Agreement? There's so many things in the Moon Agreement that don't necessarily understand in their context and how they would be applied to the use of space resources. This is Article 1.1 of the Moon Agreement that says that the provisions of the Moon Agreement shall also apply to other celestial bodies within the solar system. Therefore, the Moon Agreement also applies to asteroids and everywhere else in the solar system. When we look at later articles of the Moon Agreement mentioning common heritage of mankind, and especially Article 11.3, neither the surface nor the subsurface of the moon, nor any part thereof, or natural resources in place, shall become property of any state, international intergovernmental organization, or non-governmental organization, national organization, or non-governmental entity, or of any natural person. So nobody can own anything. This seems to be saying, whether it's a person, whether it's a corporation, whether it's a country, really closes the door to a lot of things. You could come to that conclusion. It goes on, nothing that you do shall create a right of ownership. And yet there's the balance in that Moon Agreement that the states parties undertake to establish an international regime. The reason I don't necessarily like the Moon Agreement is because I can read it and not be certain about what it actually means, what it says, and how it would be applied. This was treaty making in the 1970s for activities that 50 years later still have yet to happen. So it is treaty making and legislation in the abstract. If we want to move forward, we can come up with better solutions. There may be elements in the Moon Agreement that we like and we can borrow from, especially on non-militarization. But as a treaty, I would say it's politically radioactive. Let's move forward with something better. That's all I'll say about that. National approaches is where we're at now. The important ones, the highlight ones, hopefully draw some common elements from these national approaches, are from the US, from Luxembourg, from the UAE, and from Japan, who all have national space legislation relating to space mineral resources. So the Title IV of the 2015 US Commercial Space Launch Competitiveness Act is entitled Space Resource Exploration and Utilization. Helpfully, it defines asteroid resource and space resources. Space resource means any abiotic resource in situ in outer space, and it includes water and minerals. An asteroid resource, number one, means a space resource. So it's helpful that it is defined it. The article then the law then moves on and says that the president, acting through appropriate federal agencies, shall facilitate commercial exploration for and commercial recovery of space resources. So a kind of mandate to foster the commercial industry. That's helpful. Number two, discourage governmental barriers and stable industries for commercial exploration, etc. So those are good elements and encouragement and mandate to governmental agencies. And let's see, what else does the law do? Asteroid resource and space resource rights. A U.S. citizen shall be entitled to any asteroid resource or space resource obtained, including to possess, own, transport, use, and sell the asteroid resource or space resource obtained in accordance with applicable law, including the international obligations of the United States. So in accordance with applicable law, that kind of hints to the problem that we have. We don't know what agency we're going to approach. I'll get to that a little bit later. I don't mention the 2020 executive order on space resources or the NASA request for proposal on space resources, but these certainly form an important part of the context of the national space resource regulation and regulatory environment in the US. So moving on quickly, Luxembourg also has space resource legislation, quite boldly claiming in Article 1 of its law, space resources are capable of being owned. And it then has, the prohibition that no person can explore or use space resources without holding a written mission authorization from the Minister of Ministers. So that's who you would be approaching, the minister or ministers in charge of the economy and space activities. It is good that they have, at least we know who to ask. The United Arab Emirates, its federal law in 2019 defines space resources, any non-living resource present in outer space, including mineral and waters, and then has a few conditions on it subject to previous conditions. The conditions and controls relating to permits for the exploration, exploitation, and utilization of space resources shall be determined by the Council of Ministers and whoever it delegates. So the rules will be written by those ministers, and the permits, part 2, the permits referred to shall be granted by a decision of the Board of Directors upon the proposal of the Director General. So at least it has who we are going to ask, who's in charge of creating the rules and maybe the application form for if we want to use space resources. This is helpful. In Japan, I don't have a translation of it. This is merely a quote from, I believe this is a quote from something from iSpace saying, what the law means. The law provides that Japanese private business operators shall be permitted to engage in these activities of space resources such as water, minerals, and other non-living resources in outer space. Okay, so that's all we have, that there is a regulatory framework in Japan. We don't know how it will be administered just yet. And, I would not be surprised if other nations start drafting their own national space legislation. So that's the national approach. Briefly, I'll go over the international approach. Here's the Committee on Peaceful Uses of Outer Space, currently 94 member states and a number of observers. This year, the subcommittee decided to establish a working group on potential legal models for activities in exploration, exploitation, and utilization. Keywords, potential legal models. And I didn't highlight it, but let's see, they do have a work plan. So, happening now, the chair and the vice chair will continue consultations in the intersessional period. That's between legal subcommittee that just ended and upcoming COPUOS on the mandate, terms of reference, and method of work of the working group. And that working group will meet during the upcoming session. So COPUOS meeting this year. So we don't know exactly what's going to be in that mandate, whether the mandate will be very ambitious, draft a treaty, or more modest and pragmatic. Let's have pragmatic discussions on what nations want to do. We don't know what's going to be in the terms of reference or that method of work, although the method of work likely will follow, having the standard COPUS approach, having chairs, co-chairs, working groups, maybe expert groups, possibly along similar lines as they used for the long-term sustainability guidelines. So this is definitely something that we're going to need to be aware of and watch and be keenly following. I'll mention the Artemis Accords, which has, as of lately, let's see, 12 states which are parties to the Artemis Accords, and in those Artemis Accords, dealing with getting back to the moon and Artemis program activities, a section on space resources. The signatories note that the utilization of space resources can benefit humanity. And further on, the signatories affirm that the extraction of space resources does not inherently constitute national appropriation. So those 12 states agree to the following, that does not inherently constitute national appropriation. So at least there's 4 countries with national space legislation, and those 12 which at least have taken that position that space resource utilization is needed and appropriate and lawful. On those lines, I'll mention the ISEG, International Space Exploration Coordination Group, 26 space agencies. In their technical roadmap, they mentioned that space resources are part of their technical roadmap. I think that's important. So I see my time is running short, but this is the main ideas I want to put out there. Asteroid mining is explicitly permitted by some countries, 4 countries we know of. However, in the US, it's still unclear if the FAA or Department of Commerce would be the one issuing permits. We need to know that. More regulatory certainty exists today than even a few years ago, but some questions still remain. And I mentioned when I talk about space resources before, the same rules apply from the majority of the world. The same rules apply for asteroids and for the moon in terms of space resources. I think that will change. But the questions we need to ask is, what governmental agency are you going to be seeking permission from? We need to know beforehand, what is the application process? What do you need to disclose to the regulator to get your permit? How long does that application process take? How much does it cost? And from the regulator's perspective, we need to start thinking about, how is this interest or claim of space resources, perfected or legitimized? Do you just claim it and it's yours? That doesn't seem workable. Or do you have to prospect it? And maybe Martin Elvis will talk about how we are going to prospect some of these, resources. If it costs a lot to get to an asteroid, do we have to actually arrive at that asteroid? How do you actually prospect it? What's to prevent a gold rush of claims? That's not something that we want to have. Also, regulators, not just the lawyers, but the economists, the policymakers will need to sit down and work out some of these things, along with what's the review process for the application of claims, interagency, some type of international review process, and how will national regulators enforce claims against claim jumpers. Lastly, what are the limits or boundaries of a permit? Is it time bound? If you get a permit, you can mine asteroid X or location X for a certain number of years, and when that time is over, your mining activity is ceased. Is it extent bound, meaning you can recover X amount of tons, but no more of resource X, but no other resource, meaning you can get the platinum group metals, but the water you're not allowed to take? And is it activity bound? You can mine resources on the moon, but you must sell them to Artemis partners at this price. Or are there other constraints placed on it? Those are just some of my brainstorms. Other folks will come up with other qualities or characteristics of a permit. It may be some mix of some of those. So with that, I'm going to wrap up and thank you for your attention, and I'll yield the floor. Thank you.
Thanks, Chris. This is a very important topic, and we're going to, as he says, we need to keep an eye on things as they happen in Vienna.